This video has been designed with judges, advocates and experts in mind to show how concurrent evidence works in a civil trial. To help with this, we've adapted some parts from a resumption case where the applicant claimed $29 million in compensation. Before we take you to that case, let's remind you of how expert evidence would be taken in a conventional trial. Most of you will be familiar with the conventional adversarial process, where each party calls their own experts who are examined in chief, cross-examined and re-examined separately. This means that in the plaintiff's case, the necessary experts will be called and their evidence taken, and at a later time in the trial, the defendant's experts will be called. In many cases, their evidence will be separated by days. It can be weeks, and they will never have the opportunity to respond directly to each other's material.
Mr. Reynolds, concentrate. Concentrate on my question. It was a fairly simple question. You know that these proceedings...
Experience has shown that many experts find the adversarial process to be threatening, and they complain that they do not have an opportunity to adequately express their position. This may occur when they are being examined in chief or when being cross-examined, because they can only respond to the question they have been asked.
Now let's go back to my question. A RAMA is a heritage listed item, isn't it?
Yes.
Now that's not that hard, is it? Let's answer the questions as I ask them and we'll get through this a lot faster, sir.
Because they don't see it as a search for the truth, many qualified people have said that they will not give evidence in court. Another complaint is that the adversarial process can be unsatisfactory, because although the expert knows the question that should be asked, their advocate may not.
You included an allowance for profit and risk, didn't you?
Yes.
That was incorrect, wasn't it?
No.
That's not right.
Another problem is that although the expert advising the advocate knows the answer is wrong, again, the advocate may not.
Shouldn't profit and risk have been ignored because the valuation exercise that you were undertaking was hypothetical?
Not at all.
Experience also shows that the conventional process can be lengthy, and a great deal of time can be taken in debating matters that are of little or any significance in the resolution of the real problem. Now let me explain to you how concurrent evidence works. The first step is for the experts to prepare and exchange their written reports. This is a step sometimes taken in conventional litigation. With concurrent evidence, the court will always require the experts to meet before the trial and identify the areas in which they have a common view and the areas where they disagree. They are then required to put on paper a statement of their position. At the appropriate time in the trial, the joint statement will be tendered and the experts called to give evidence. I have presided over cases where as many as 8 experts have been called to give evidence at the same time. Imagine how much conventional courtroom time that can save. Once sworn, counsel for the parties are asked by the judge, working from the joint statement, to settle the topics which the court will have to consider in order to resolve the differences between the experts. This becomes the agenda for what I refer to as a structured discussion. As I mentioned earlier, we are going to illustrate the process from a case which involved valuing a major golf course development in order to determine the compensation payable by the electricity authority which constructed a transmission line through the property. There were 2 parties, the owner and the authority, and each of them had retained 2 valuers. The valuers each had different views as to the appropriate compensation. What you will see are excerpts which we have taken from the actual transcript to illustrate the process of concurrent evidence. Now I think perhaps you all understand the process that we're going to go through, but let me just explain it to you again. I have here, as you know, the document that you've prepared which shows me where you agree on things and where you disagree. That's our starting point. I'm going to invite counsel in a moment to tell me of the issues which they believe need resolution And then I'm going to go from the list of issues that we agree to ask each of you to contribute to a discussion about those issues. You'll have the chance to ask each other questions and a chance to tell me of your position in relation to those matters. Now, you should also understand that I've had the chance of reading your written reports, although I don't profess at this stage to fully understand them. It's important that we all agree that the process is not an argument. Rather, it's a discussion designed to inform me of your position in relation to each of the issues. Mr. Coles?
If Your Honour, please. It seemed to us that we might explore firstly the question of methodology, or what I might describe as valuation rationale. In particular, we would, from our part, see benefit in focusing on the question of the respective valuers' approaches in not adopting, for whatever reason, a simple before and after approach in relation to the golf course. Then it seemed to us that it might be appropriate to explain or explore the question of sequencing or staging of the hypothetical development. And then lastly, it seemed we would need to look at the question of explore the experts' views on the market for the sale of development property in the Bonneville area.
Yes, Mr. Ayres, do you want to add to that?
No, Your Honour.
Yes, all right, well, you understand where we're going. I think there's a roving microphone there amongst you, is that right?
Yes.
Well, the rules of the process are that you can only talk if you're holding the microphone. You understand? That avoids you talking over the top of each other. Now, you've heard the topics that have been discussed by counsel. The one that interested me at the beginning of the case is why you just don't approach the problem on a straightforward before and after exercise. Now, who'd like to tell me about their perspective on that one?
I would, Your Honour, because one of the problems that I had, and I did initially take the obvious approach, but one of the difficulties when looking at the scale and scope of the project on the before situation is that a significant proportion of the development is for lodges, and primarily on the western side of Cassidy's Road, which is dominated by lodge-style developments and additional retreats. Now, the problem that I had when trying to determine a timescale for those is quite simply that there are no other comparative style of property that I could ascertain within Australia of a similar type of property or a similar style of property.
But I'm not sure I understand why you would need to do that. Why wouldn't you just look at the value of the whole property without a transmission line and ask yourself, what's the value of the property with the transmission line?
Certainly. Well, when you look at the plans for the development and you also look at the land with the line across it, it becomes very difficult because there simply aren't any similar properties available for you to reference against within the country. There's no yardstick.
I understand that, Mr. Blaxland. Perhaps I'll now throw it open to anyone who wants to contribute to the discussion.
Your Honour, I can only comment that my experience is transmission line easements or similar easements, and it's common practice for valuers to assess compensation on a piecemeal basis. The complexity involved in performing what we all know as a complete before and after on the property was something that I felt introduced matters and difficulties that have a tendency to complicate rather than address them, and so I chose to do it on a piecemeal basis.
Yes, very well. Can you tell me, when was the property acquired by the current owner?
My understanding is about 1998.
Beginning of 1998, actually.
When it was acquired, it was affected, was it? But there was a right to compensation?
Yes.
No, there wasn't.
No, it actually acquired more than a right to of compensation.
I see. And at that stage, was there a transmission line on the property?
Yes, there was a line that ran through the property, but there was no easement over that line.
So there was a line, but query how it got there, and with whatever visual impact that line would give. But the sale occurs, as I understand it, with the expectation that if there is compensation over and above, that comes to the purchaser. Now, is my understanding of that correct?
Well, that is my understanding, yes.
That's clearly provided for in the contract, Your Honour, the contract for sale.
Yes, thanks. As you can see, during the opening part of the discussion, it is important for the judge to provide an opportunity for everyone to contribute. It is also important that the judge ensure that the discussion is confined to the topic which has been identified. It is also a useful step to provide an opportunity to summarise issues along the way. I just want to make sure we're all on the same ground at this stage. You say the sale price, if that had occurred at that day, would give you the maximum value of the property unaffected by the transmission line. Is that right?
Yes, Your Honour.
Now, do the rest of you agree with that proposition or not?
Your Honour, if I may, I think the key question here is whether a hypothetical purchaser would pay any more or any less for the property in the before and after situation. So one of the considerations of the hypothetical purchaser in arriving at the highest and best use potentials of the land would be to consider the master plan and whether that master plan actually added value in the before situation or made any difference, or similarly in the after situation would consider the impact of the proposed works on the master plan.
Now that we've introduced the first topic and all of the experts have contributed to the discussion of that matter, if counsel have not become involved, it is sometimes necessary to actively draw them in. In my experience, when counsel are new to concurrent evidence, there may be some uncertainty as to how they can best contribute. However, inhibitions generally fall away quite quickly. Yes, now thank you, that's probably enough from me at this stage. It helps me to understand a little bit about the matter. You understand I don't find this to be an easy exercise. It's not a conventional problem by a long way. Mr. Coles, do you want to start now with methodology? I think I've gone part of the way there, but do you want to continue the discussion?
Your Honour, please, there are some matters that we'd like to take up with the expert witnesses. Perhaps if I might commence this way, can I first seek to confirm from the witnesses whether there is indeed a broad general understanding that they share that in this particular case it's very difficult to do a before and after across the board sort of assessment, let's say in this particular case.
Yes. Yes.
There doesn't accordingly seem to be particular dissent about that proposition. Now, as part of the reason for that, the fact that in some instances at least golf courses may come to be sold for a price actually less than the construction costs.
Yes, that is an issue. However, I don't think that is actually a factor that would come into whether or not you would do a before and after of the total value.
Now, is it correct to say that there is no clearly identifiable comparable golf course with a transmission line going through it that could be taken into account by valuers in the assessment process in relation to this particular golf course?
Yep.
I'm not aware of any comparable.
I think, Mr. Wentworth, you may be able to tell us something about this.
Yes, just to answer your first question, I don't believe it's an insurmountable problem to undertake a before and after analysis of this property. I'm not suggesting it's as straightforward as having the luxury of a sale immediately next door, but valuers in their normal course do make adjustments for the differences between the sales evidence and the subject property. So I've adopted a piecemeal approach to this exercise, but also considered the location of where the property is. It's in Coffs Harbour, and how that location would affect the potential of this property. And I believe a before and after exercise can be supported.
And can I ask this one to Ms. Burke? Would you be of the same view as that expressed by Mr. Wentworth?
It depends whether your question relates just to the golf course or to the master plan as well.
Yes, I see. Very well then. I think, if Your Honour please, that's all I wish to inquire of the expert witnesses on the methodology issue that we're waiting to find.
Yes, thank you. Mr. Rearies, do you want to join the discussion?
Yes, Your Honour. The sale of the property to the applicant was by the contract date of the 10th of February 1998, and the easement was resumed on the 5th of February 2001. So there was a period of 3 years between contract and resumption. And the only factor that changed in that period with respect to the property was that the master plan consent was granted by the council, and there were two options entered into by the owner of the golf course, and they were over lots N and O. And both of lots N and O, although they've been have slightly different zoning, and there's a foreshadowed support of a rezoning by the council, give you a reflection of market value.
Sorry, give you a
market value.
Well, look, I don't think in relation to the properties that were under. And look, there may have been some adjoining owner who was trying to influence what was ultimately played. But the owners did want to do something in relation to the golf course.
As you can see, we have edited the transcript. The full version makes for boring television. However, you can now understand that the process allows the experts and the advocates to contribute to a joint discussion of particular topics. It is important that the judge maintains control of the discussion and, when appropriate, moves it forward. I'm sorry, I think I've diverted us a little. Where do you want to go now, gentlemen?
For our part, Your Honour, there are some further matters we'd like to explore, but I don't think I need to explore any further the issue which Mr. Blaxland has just developed. We'll move that to submissions.
Well then, just looking at our agenda, as far as our topics go, we've now covered, I think, methodology and individual approaches.
Indeed. There is a, if I may turn to a fresh matter, Your Honour, there is a matter I'd like to raise in the first instance and direct it to Mr. Blaxland. I think, Mr. Blaxland, you have seen a document which is on yesterday added to the evidence as part of Exhibit V, is that right?
As you can see, the discussion is now moving fluently with all of the participants involved. Experience also indicates that the level of tension in the courtroom falls away in the concurrent process. The adversarial contest gives way to a genuine exchange of expert views. Another benefit from the process is that because the experts know that they can be asked questions directly by their colleagues, the quality of the evidence significantly improves. The half answer in the hope that the advocate will not know what has been left out is no longer possible. The wrong answer can be directly exposed by a question from another expert. Let's show you now how the witnesses can become involved in direct responses to each other's comments. It's an example from the trial where Mr. Blaxland commences the exchange.
But the type of townhouse development that you will get in this area, well, you know, they're going to be sitting down and making assumptions as to whether they can get the majority of those in as they appear. They're not going to be sitting down looking at the bits and pieces and how they can move the pieces and so on and so forth. I mean, well, you know, if they can go beyond that, well, all the better for them. But basically, they're going to be sitting down and they're going to be looking at what the essence of the principal approval is.
Right, Your Honour, if I could just maybe add my views on that. I was previously asked to have a look at Mr. Blaxland's assessment as it appears in Schedule 1 of his Statement of Evidence and replicate that, which I have done. I was then asked to apply Warren and Cashman's figures that were discussed this morning, and once those figures, if accepted by the court, if the court finds that Mr. Blaxland's basis is correct, and then you apply those costs, it results in a loss of $578,000. Really, it doesn't matter where the units are, whether they're within the easement or... And if you accept the $495,000... What should come into it, as Mr. Blaxland has done in Schedule 1, is that he's included development costs of 10%, which is not included in the hypothetical development analysis handed up this morning. There are other costs there, as I say, costs that were project specifics which have been excluded from Mr. Blaxland's exercise. We've discussed air conditioning and also site infrastructure, excluded from the costings that were provided by Warren and Cashman.
Your Honour, that's just simply not correct. And I mean, I haven't seen Mr Wentworth's exercise, but if he's simply just added in figures that the quantity surveyor has suggested that I've already included, then there's a whole lot of double dipping going on. In regards to the interest, I haven't seen that document that was handed up, and so I'm not quite sure what Mr Wentworth is saying there, but I have certainly included more amount for interest than the quantity surveyors have suggested in my exercise, and that has not been excluded from that exercise. And so I'm not sure where Mr Wentworth comes up with this negative figure if he's simply adding in figures that I've already included across a number of different elements. I mean, if they've already been allowed, then why would you allow them again?
Your Honour, I've been very careful not to double dip. I have a copy of my calculations, but I only have one copy here.
Yes, yes, thank you. If you can just give it to the officer, we'll get it copied. Some people have expressed a concern that if there are credit issues that need to be raised with a witness, this cannot effectively be done during concurrent evidence. This is not the case, as the following extract from the trial shows.
Mr Blaxland, you began your first report's analysis at page 40 in Schedule 1 with an in globo per unit loss of $56,000 on this hypothetical exercise. Is that right?
Yes, that's right.
And to arrive at that, you assumed there'd be gross realisations based on a sale price of $495,000?
Correct, yes.
In today's exercise, Exhibit Y, you've assumed a higher sales price of $530,000. Is that right?
Yes.
But you got an in globo land value per unit lost of $45,760. Is that right?
Yes.
So that what's happened is that the price of the land has gone up, but the value's come down in your analysis.
So price of the land, you mean, or price of the unit?
Well, the sale price of the units has gone up, but the land value has gone down.
Yes.
And you've reduced the risk. Is that right?
Yes.
Doesn't make any sense, does it?
Well, it's just a calculation, which is relative to the agreed costs from all the other experts in relation to infrastructure and landscape and the like.
I suggest to you that what you've done in Exhibit Y has no intellectual integrity, does it?
I reject that.
Finally, it is necessary for the judge to ensure that everybody has had the opportunity to put all relevant material into the discussion. Yes, yes, thank you. I think that brings us to the end of the topics that we needed to discuss, but is there any aspect of the matter that any of you wish to say anything further about?
No, Your Honour.
Yeah. And what about you, gentlemen? Mr. Coles?
Would Your Honour just pardon me while I speak to Mr. Hemming? Not if Your Honour, please.
And Mr. Aries?
No, I'm not going to part of it.
Well, that brings us to the end of your part in this case, but thank you very much for your careful thought and attention. But you're now excused and free to go, but of course counsel may wish you to stay to help them later in the case. But thank you very much. There are also many advantages in concurrent evidence from the expert's point of view. Many of them have told us how the process allows them to express their opinions without the inhibitions that come from the conventional method. They also believe that their opinion is given greater value. Many have told me how they now believe the inquiry is genuinely directed to identifying the truth, rather than a game controlled by the advocates, where the only objective is to win the case. Here's what some of them have had to say.
Having appeared in the courts over many years as an expert witness, I've experienced the formality of the adversarial system, but in my view, the reforms of the Land and Environment Court that encourage concurrent evidence create an atmosphere of informality, allowing an open discussion and a free flow of ideas. And I believe that this is an environment where the expert can more readily fulfil their primary responsibility to the court to best inform the court based on their knowledge and experience, and to deliver the highest possible level of intellectual integrity in providing their evidence.
What concurrent evidence does is to provide an opportunity for the court to ask very specific questions of the experts and for the experts to respond to those specific questions so that there's no loss of court time in dealing with extraneous matters. It also provides the experts with an opportunity to address matters that might arise through the other experts' evidence and to address those to the court so the court can understand the attitude of each of the experts. It also provides a system by which the adversarial system is completely done away with in the court so that people feel more comfortable in the way that they are responding to the court's requirements. And it also means that it provides a method by which the experts are able to give the court what the court would see as being relevant information to the decision making that it has to undertake in the process. And in my opinion, it works well.
Concurrent evidence probably has its singular advantage, most important advantage, the fact that different experts can discuss in front of an informed audience exactly what are the merits or otherwise or disadvantages of any proposal, and offers an ability to be able to check one view against the other, to have competing views discussed, even debated, perhaps even with a little bit of heat that never hurts, and at the same time provide an informed commentary on a whole lot of aspects, not all of which each expert may have thought of in the first place, but certainly they are brought to have to think about them together. So as far as I'm concerned, it's a fantastic way of exposing both the advantages and the flaws of any development, and it offers a possibility for an independent judicial observer to actually make a decision based upon a real, in fact, or in a real-time debate about what is being discussed.
Well, in my experience, concurrent evidence can be a very useful tool for focusing on the issues that are determinative in a matter. I think it's important in those cases that the proceedings are tightly controlled from the bench. That way the witnesses remain focused. Otherwise, what can happen is if the lawyers at the bar take over the proceedings, then it's possible for them to become distracted and to divert off into areas that are not those matters that are most important to be determined.
Professor Mackay has emphasised the significance of the judge chairing the process. The role of the advocate also changes. They are required both to participate in the discussion and also ensure that the experts retained by their client adequately explain their position. They must also ensure that the opposing expert is effectively challenged. All of this requires additional skills. We've asked some advocates to tell us of their experience.
There are by now a whole host of benefits that are well known about the concurrent evidence process. Importantly, it shortens the hearing process, but at the same time permits the court to be fully informed of the entirety of an issue in one sitting. There are a couple of things that the concurrent evidence process is not, however, and importantly, one of them is that it is not the panacea for the lazy advocate. If anything, it's the absolute opposite and requires the advocate to be more fully prepared to deal with the entirety of the evidence that he or she may have to deal with in cross-examination. Because unfortunately, the witness that might previously have been, or the expert that might previously have been sitting there whispering in your ear to help, is now up there on the other side of the bar table participating in the process.
There's a real advantage, as I see it, in the process of having the experts giving their evidence all together once all the other evidence in the trial is in. This ensures that they're all focusing on the real issues as they have finally emerged at the end of the trial, rather than addressing the evidence in turn, as it were, on the run. And a real advantage from an advocate's perspective is that we can really use the collective processes of supplemental oral evidence in chief, cross-examination and re-examination of witnesses by in effect using one witness to aim a question at another witness so that the whole process is proceeding all together, and that's a real advantage in being able to get the material out.
One of the advantages of concurrent evidence is that you can get the experts identifying their points of agreement and disagreement where they're being cooperative and professional. That enables the advocate to hone in on the particular aspect of the case where you're trying to get a concession or move the consensus of the experts as they're sitting together in the box towards the point of view you want to have. Of course, you have the disadvantage that your opponent might also wish to move it that way, and the judge will be seeking to try to get to the actual truth of the matter as well. But it works very effectively when you have that cooperation. There'll be other times when the experts don't all cooperate in that search, and in those situations you can use your ordinary skills as an advocate with a normal old-fashioned cross-examination as to credit, but you need to make it tailored, pithy and to the precise point that you are seeking to challenge the expert on. At the conclusion of your cross-examination, hopefully it's been effective, you can then turn to your expert or experts and say, well, what did you think of that? And that again is something quite extraordinary and unusual, but it's a very useful feature of the procedure because it enables everyone to express a point of view on that particular topic straight away and allow all in the courtroom, including the judge, to grasp what that issue is all about. One of the other things that this process teaches you, and I'm only in the learning processes myself, is how quickly the case moves as this process goes on. Instead of having cross-examinations such as with valuations that will take 1 or 2 days per valuer each, you'll get the whole of the 4 valuers, as we had in this particular example, over in a day and a quarter in the trial. That means your preparation has to be much quicker, everything is faster and more compressed, and you need to keep up with it. And again, that throws up a challenge of the system, but it means it gets the cases moving and it gets to the real heart of it far more quickly, and I think in many cases far more effectively.
You can also appreciate that because the judge sees the experts talking with each other, it is much easier to understand what they are saying and work out the evidence you will accept. Justice Lockhart, who first used concurrent evidence in the federal court, has this to say about the process.
Concurrent evidence was first introduced in this country by the Australian Competition Tribunal, of which I was president quite a number of years ago. Introduced by me as president and by Professor Maureen Brunt, an economist. It has been adopted since quite widely in Australian courts, including the Federal Court, of which I was formerly a member, and is in the process of being adopted by a number of international tribunals and by tribunals, including courts of other countries than Australia. The benefits to the judiciary, I think, are very clear. They enable the expert evidence to be commenced and completed in a shorter time frame than otherwise would be the case, and with less expense to the parties. But primarily what it does is it defines more precisely the true issues in the case, both matters of expertise and of law, and of course of fact. That also must assist, I think, the experts and does assist the advocates in the way they pursue their case. I found it to be of immense value, and I know the economists all went away from the court thinking it was a useful system because they felt they'd made a real contribution by being able to give their evidence without the necessary interruption of cross-examination at all points. And I thought when counsel got used to the system, they readily adapted to it, and it made full use of their expertise as advocates in cross-examining on the issues that really ultimately mattered. The only limitation I'd put upon the use of concurrent evidence is that one has to be careful, and this is a matter for the judge, of course, who hears the case, to ensure that not too many experts at once give concurrent evidence. There's no maximum number, that's for the judge. And that not too many fields of expertise, different fields of expertise, give their evidence at the same time. But again, this is a matter for the trial judge to determine as he or she thinks best. I found that I could take up to 9 or possibly 10 experts as economists in one sitting. Beyond that, it gets a bit unruly. But no doubt you could have 2 sittings of the experts if you wish to. But I emphasise it's a matter for the trial judge to adopt and in consultation with counsel. However, I've read and heard what the witnesses have said about this themselves for the purposes of this recording, and what advocates have said, and I agree with everything that they have said. I can only add what I have in relation to the judge's point of view. I do recommend the system to all people who practice in the law as a very useful system, saving costs and honing down the issues more completely and accurately.
Well, I trust this DVD has given you an understanding of concurrent evidence and how it works. It is a significant change which you can see has many benefits. A moment's thought will tell you why the process has advantages. In our ordinary professional lives, if we had a problem involving a conflict of expert opinions, we would not set up a court case to resolve it. What we would do is arrange a meeting between the experts so that they could talk it through with the ultimate decision maker. For example, a life-threatening illness is often treated by a team of doctors who talk to each other about the best way of handling the problem, and a final decision is then made. If that is how professional people work, then why shouldn't courts work in the same way when problems involving experts have to be resolved? Many courts and tribunals have already adopted concurrent evidence, and I'm sure its use will increase. I hope this DVD will prove helpful to both lawyers and experts in making effective use of the process.